So, in today's episode, we're going to be talking about how beneficiaries can receive a cash advance on their inheritance. So, normally, when you're going through a probate process, your inheritance can take 6 months, a year, 2 years, 3 years to receive, just depending on which state you're in or if it's a litigated case or a non litigated case. So, in today's episode, we have the founder of Probate Cash, which basically does cash advances on inheritances. We have Mark Harris. Welcome to the podcast. How are you?
Good, Jose. Thank you very much for having me. Looking forward to it.
Likewise, good. So for viewers that maybe don't know what Probate Cash is, what is Probate Cash and how does it work?
Sure. So Probate Cash provides advances to beneficiaries of estates who are waiting for their inheritance.
Okay.
What we do is, in exchange for usually a portion of the inheritance, we're not buying the entire inheritance in most cases, but in exchange for a portion of the inheritance, we'll pay a purchase price today, and then we will wait until the probate case concludes before we receive our repayment. And it's an assignment of an inheritance. It's a purchase agreement, a purchase transaction, as opposed to a loan.
Got it. How is it calculated how much somebody can receive as an advance on their inheritance? And also, is there like a certain ideal amount? Like if I'm receiving a $10 million inheritance, could I receive millions of dollars in an advance?
Yes, you could. Our advances, there's really not a limit of how much money we'll do as far as an advances. What we're considering is in our underwriting, are you indeed a beneficiary of the estate, and what is your inheritance going to look like when it's time to get paid, when the court orders the distribution of the assets. So uh, we take different risks that are inherent in the probate cases. That's creditors' claims, potential challenges to a will. Those are all areas of the probate case that we're making advances against the inheritance, which is subject to, of course, those creditor claims or other challenges. Uh, the advance amount, or more like a percentage of what the inheritance would be, also depends upon what stage of the probate case. So at the beginning of the probate case, we're not going to advance such a high amount of money. We want to see how things play out, but we will. Well, we do advance. We may advance 25% of the amount of the inheritance, something of that nature. And then the case is filed. We get an idea of the inventory. A personal representative is appointed to confirm that inventory. So oftentimes we're making advances before there's an executor, and therefore we can't really confirm the assets or in the account. We have what's been told to us and what may be filed in the inventory, but no one's really checked on it. So we're still waiting for that. Once the assets are confirmed, then will make a larger advance. Our appetite is increased at that point. Then when the claims period is completed, and we know now that the claims, what claims, if any, have been made, that would affect, of course, the beneficial amount of the inheritance. So that's another stage where we can advance more money. And then all the way up through the petition for final distribution. Of course, if there's a petition for final distribution and we can see what everybody we believe will be receiving, we can then provide a larger advance as the beneficiary deems necessary. The big thing is what does the beneficiary need? What is their purpose? And then we can tailor a transaction around the beneficiary's need. So it's not an all or nothing. And a lot of beneficiaries will come back for multiple advances as they see if their needs change after receiving some money up front. Then it depends. It really depends what their needs are.
Got it. Who typically comes to you? Like what amounts does your typical beneficiary ask for? And then also like at what stage is it most common that they come to you? Do they come to you very early on, meaning pre-appointment? or do they come to you typically after somebody's been appointed as well too?
Yeah, both. You can imagine for the people who had never heard of the probate process and thought they were going to be receiving money at
Right away.
yeah, right away soon after the funeral, it's a big shock to them that there's this probate process that is going to last a year or so, and that's if it's non-adversarial. And so those folks often needed were counting on their inheritance to either live, I mean, truly live, or to in some cases the administrators want to fix up the property. They need to do stuff with the estate assets to get them ready for sale, or at least for fair market value. And so initially there's this panic that says, wow, I never thought it was going to be a year. How can I get some of my inheritance? They like that it's non-recourse, that we're taking the risk of the claims and anything else that could be out there. So that gives them a little bit of peace of mind. And then, if they choose, it's up to them to take, of course, take the advance. Sometimes they say, okay, I'm going to wait it out. Maybe it won't be, the probate case won't take as long. And then they come back to us as they realize that, wow, nobody's even been appointed yet. So now can I get an advance? Or all right, they finally were appointed. Can I get money? So it's at all stages. We have people that come to us at the time the petition for final distribution is filed, and they may come to us for the first time at that point. So it's a need basis.
Okay.
Um,
How does the underwriting process work for you guys? Because we talked off camera how I've done certain advances when somebody needs to repair a property at times, but I'll do a note in a deed of trust, which in my opinion, I do a title search. I basically do a statement of information to make sure that my loan has a secured position on it. Yours is a little bit different where there isn't somewhere where you can or can you record something to protect your interest, or how does that underwriting? How does the process work on your guys' end?
sure.
Uh,
So there's actually a mechanism. There's a statutory mechanism in California. So we do business throughout the country, but we do a significant amount of business in California. California has a statute in the Probate Code 11604.5. 11604.5 of California's Probate Code. And it's actually a law that governs how one assigns their inheritance to a third party. So, um, I said before, it's not a loan; it's a purchase. So we're not. It's not a loan where we are looking at the heir and say, okay, what kind of credit score do you have? What kind of collateral do you have? We're going to take a security interest in the estate property. First of all, we're often doing. We're making an advance to just a beneficiary who's not the executor. They don't even have the legal authority, even if they wanted to allow us to take an encumbrance on the estate property because they're not the administrator. Uh, but what we do is, said, what's the underwriting process? So a probate case has almost always been filed, and we have a team of underwriters, a lot of paralegals and folks from the mortgage industry who that will look in the case file, and we see who the beneficiaries are, whether there was a will submitted, if not, what's the intestacy family tree look like, who's getting what, and we take a look at the case. I am somebody who I'm an attorney. I find the best practices, of course, are transparency, transparency, transparency. We, as a practice, contact the attorney representing the estate. We let the attorney know that a beneficiary, if not the attorney's client, the administrator, another beneficiary has requested an advance, and we just kind of talk to them, get the oversight of the probate, whether they believe anything special is coming down the pipe, any claims are coming down the pipe. Usually, we get a pretty good level of cooperation from the lawyers. Um, we don't need their cooperation necessarily. We don't need their authorization or permission, nor do we need the administrator's authorization or permission to do one of these advances. But it's always nice that they at least know that it's coming if they're not totally cooperative. So once we talk to them and combine with our underwriting and what stage of the probate case we're in, at that time we will make an advance to the beneficiary. They'll sign a purchase agreement with us, which covers the terms, how much of an advance they'll receive, and how much they have to repay, depending upon what date they repay that advance. And then they also execute an assignment. And it's that assignment which says that how much money they're going to pay probate cash. And it's kind of just gives everybody who would be looking in the public records or in the court, I should say, on notice of our advance and the assignment. And we file that with the probate court. And it's all part of actually the California Probate Code I reference. That's filed, and then in California, the estate attorney is actually required under the probate code to include us as a payee, assuming the assets are available. We would step into the beneficiary's shoes there. So if the beneficiary assigned $50,000 of her inheritance to us, and that beneficiary was going to be walking away with $100,000, in the order for final distribution, we should be included for $50,000. It's all, of course, under the review of the probate judge, who has final word. The probate judge can take a look and exercise her own discretion of, but usually that's that's just it's something that gives the judge has the authority to review it, but the law actually wants to make sure it's consumer protection oriented, as you can imagine, especially in California. And the law says that the court can say, hey, we need to make sure that the fee is reasonable that's being repaid, and that everybody understands what's going on. So we have a pretty basic contract that lay people can understand. And then I'm a little paranoid as a lawyer. I also conduct a recorded telephone call, our office does, with our customer to go over the terms as well. And so we have that recorded call, and they understand what they're receiving and how much they have to pay back at the end. And they can pay it back anytime, but usually they don't have the assets until the probate case concludes.
Got it. So when you say pay it back, I got confused if it was a purchase or a loan. That was the confusing.
Yeah, sorry. Yeah, so I'm being lazy with my words with pay it back. So it's the assignment. So they're going to then assign us at $50,000 of their inheritance, and when it is time for us to be repaid, that's what's being repaid, the assignment of the inheritance, the assignment amount. And so it's $50,000. Let's say in that situation it'd be $50,000. So whatever the beneficiary would be receiving at the end of the probate case, if it's $100,000, $50,000 would come to us, $50,000 would go to the beneficiary. If in that situation the beneficiary was only entitled to receive $30,000 because a creditor claim wiped it out, medical bills, Medicaid, something big came in that situation, that is our risk, and we would be shortchanged. Instead of getting $50,000, we would get $30,000. And so one thing that's really important for lawyers who are listening, or administrators, other beneficiaries, is that we're only in contract privity with our customer. And so if there's any shortfall, we do not look to any other beneficiaries for repayment. We don't look to the estate. We're not a creditor of the estate. We're just a party under contract with a beneficiary who has assigned us a portion of that beneficiary's inheritance.
Got it. As you go through your underwriting, what are some of the red flags that you're like, hey, look, if I see this or this, it's very unlikely that we'll be able to do business? And then the follow-up question to that would be, let's say you receive an assignment of $50,000, assuming it's like pre-administrator being appointed. Like, do you guys pay 10 cents on the dollar at that point, 20 cents on the dollar, 30 cents on the dollar? And then how does that change after somebody's appointed claims? I would imagine that pre-administrator may be a lot lower, and then once the petition for final distribution a lot higher because the risk shifts in that time period.
Sure. So red flags can be certainly anything from somebody contacting us and believing that they are an heir.
Beneficiary.
I'm sure you've seen that maybe once or twice.
Yeah.
So we do a judgment and lien search on our customer, and we also do it on the decedent. We want to see if the decedent's got a whole bunch of claims potentially coming down based on their track record. We look at the real property. Does the real property have, is it underwater? Does it have equity? What kind of equity does it have? If it's, is there a reverse mortgage on the property? At the end of the day, when the property is sold, what will the beneficiaries actually receive when all the encumbrances are satisfied? If, like anything, if the mortgages are pretty high and the asset at the end of the day when it's sold, there's not going to be a lot of money there to support repayment of an advance to assign it, it's just not going to financially work.
Yeah.
Other red flags, anybody living in the house. For the most part, the house is the asset. So that is very important. That the real property is going to be sold, that's what we're looking at. So if someone's living in the house, are they moving out? Is it our customer who's living in the house? Is it someone else? And what are the plans? So that's when we try to really talk to the attorney, the administrator, and see if they're going to, if there's a plan to eventually sell the house and a real plan. If there isn't, that's a little bit of a concern. That's a red flag. Doesn't mean we won't go forward, but it's a concern because someone does have to sell the house. So that can be. Other red flags. They're not. There's so many things that can come out. All the probates are different, of course, and issues with the house. Is the house in what kind of condition is the house in? And those are, of course, just go to whether the house has enough equity to support the inheritances to be sufficient enough to repay us. Does the attorney have any stories or know of any challenges that are coming down the line? Was there a opposition to who's going to be administrator? So if they're competing claims to be an administrator, you may say, "Oh boy, here we go. This could be an interesting one." Is it just simply a couple of people want to be the administrator, or are there going to be more fights down the line? And that's okay. But those are things we have to consider. That's all. But we even make advances into adversarial situations where people are even challenging their whether they're an heir, their heirship. So that's those are some of the red flags that make us pause or tell us, okay, let's move forward. As far as the second part of your question, our fees are pretty much stay the same regardless of what stage we are in the probate process, but how much money will we advance is what really can change. So if someone comes to us and says, I just hired an attorney, I'm going to open up probate, the decedent just died 2 weeks ago, and I need $100,000. Even if that heir was going to be entitled to $10 million, we may not pay $100,000 at that early stage. We want to make sure that that heir is truly an heir, that there's not a will that's going to pop up somewhere. So we want to really make sure it's not just somebody who thinks they're an heir, wishes they were an heir, and or knew they were actually disinherited already out of the estate, but they're trying to run to the court and become an administrator somehow. So we've seen it all, as you can imagine, or I hope we've seen it all. I'm sure we haven't, but we've seen folks try to take advances from us who are not even beneficiaries in any way, shape, or form.
Got it. Okay. And then is that usually like 10 cents on the dollar, 20 cents on the dollar, 30 cents on the dollar, 50 cents on the dollar, 70 cents on the dollar? Is that private or
It's not private. It's I mean it the fees really do our fees reflect kind of the risk of the estate. At the beginning of the process, though, we usually charge a fee of anywhere from 15 to 25% of the advance amount. So if it's a $10,000 advance, 25% of that on the high side for it could be $2,500 fee. And the fees do go up depending on how long the advance is out. We like to cap it. Again, it's also under review of the probate examiner in the courthouse and the judge. We have the attorney on board. So, we talk to the beneficiaries, make sure that they're using the money for the right reason. It's up to them to use it, but it's not really our business what they use it for. But I do caution folks, these aren't loans at a mortgage rate. This is not something that I would use would take the kids. I wouldn't use our company to get an advance to take the kids to Disneyland or a cruise. I'd be using the funds for necessities, for helping fix up the property, to get a fair market value for the sale. A lot of times the administrator's doing the responsible thing. The administrator is fixing up the house for sale, but the administrator has a few siblings who are not nearly as patient, don't understand the probate process, and they really do need money, and they're pushing for a sale. Just sell it to a cash buyer, sell it cheap so I can get paid. Well, the administrators will then be able to, when they're looking for a solution, they contact us and say, hey, can you give my brother an advance? They need $10,000, $20,000 while we're getting this house ready, because that $10,000 or $20,000 we need a few months to prepare the house for sale, which is the difference of selling to a cash buyer or fair market value, which is going to be a couple $100,000 difference of what the value will end up being.
yeah. Okay. And then how long does it take for somebody to qualify? Like, meaning, like, I come to you guys, it sounds like you guys are talking to the attorney, you guys are potentially talking to an administrator, you guys are looking into the condition of the property. There's a lot of different things. Is that process like a week, a month, 2 weeks?
It's actually often very fast. We're looking at the property. I mean, in this day and age, you can take a picture of the property on the outside of the home very quickly. You're not going to be able to see everything. You heard our fees. Our risk tolerance is higher than most folks are, and our fees reflect that. But we are immediately the heir will sign a basic application that shows us where the case is. We look that up. Everything's online. In almost every jurisdiction, it's online. So we're able to take a look at the pleadings, review those. We do put a call on to the attorney. If we can talk to the attorney
Great.
quicker, all the better. So what is it normally? Normally, we can provide an advance with the attorney's cooperation, the estate attorney cooperating as well, within 1 business day.
Wow.
And so that's really, so even folks who can qualify for a more traditional loan at an interest rate of a bridge loan, 10%, 12%, in the teens, whatever that may be, they're still going to have to wait for a loan approval. They have to show collateral. It takes time to get a loan. And we understand that most of our customers have an urgent need for an advance. When you start with the premise that so many of our customers never had heard of probate and thought they were going to be receiving money shortly after the funeral, and now look, and they were planning on that. That's the need is really urgent for a lot of our customers.
Got it. Do the estate attorneys ever oppose or advise against getting some sort of advancement to the beneficiaries? And obviously, you guys don't need their approval, right? So if the beneficiary wants one, and if they ever oppose, what would be their opposition to it? Like, meaning, if you guys are advancing money, you guys don't have a say. Like in California, there's a notice called the Notice of Proposed Action, where it gets sent out to beneficiaries, and the beneficiaries have a certain amount of time to either object or approve. Do you guys become part of that notice now at that point, or no? Or
Well, we
does that?
file a notice of the assignment with the probate court, so that's right there for everyone can see, and we provide a direct copy. We'll provide to the estate, to the attorney that represents the estate. So those they can see that immediately. Most of the lawyers in California are actually familiar with probate cash in our business. It helps that we have that probate code and that they have that familiarity. So, and they remember again, they represent the administrator, not the beneficiary. So that's not their clients. But if an administrator wants an advance, they may say, you know, if you could wait, it's better, just because of the fees involved. They could oppose it. They also do have to, as I mentioned, put us back into put probate cash, include us in the petition for final distribution. And so there's a law, part of the probate code does say that we have, I think it's like 15 days before a hearing is scheduled for to be heard on the petition for final distribution. We have to have everything in by then, but as long as we do, then the lawyers have to at times supplement the petition for final distribution to include us. So, you know, we recognize, and that's why we want to work with the lawyers, that can be burdensome and could be a little bit of a cost to the estate as well. So I'm very cognizant of that, and I don't want to put the lawyers in a bad position, and it's balancing the convenience of the lawyers having to do that versus the need of the beneficiaries to have money right away. But for the most part, the attorneys are on board, and but if not, it's you know, I respect the decisions, but it's their client or their beneficiary's decision. So we've done many advances where the attorney has counseled, you shouldn't, but you know, at the end of the day, like I'm a lawyer. My clients have often not done what I've advised, and then you know I stick with them and want the best for them. Want the best for them.
Got it. How long does it take for you guys to typically get your money back?
So it takes as long as usually it takes as long as the probate case does to conclude. So yeah,
A year, 2 years, 3 years.
yeah, we have. I mean, we have advances out in New York in the boroughs that have been out since before COVID. So I mean, we're talking 5 years. That's not our business model. That becomes part of our risk and concern. I mean, that's no good for us or anyone. It's obviously a good need for the beneficiaries. They've been having the use of our money for a long time, but it really just depends on the case. While the beneficiaries can repay us anytime, they can prepay. There's no penalties to prepaying us. And it's in their best interest sometimes to prepay us if they can get their hands on money to do so. But usually it's at the end when the order for distribution of the assets has finally been approved by the court, and the personal representative starts writing checks. Like even when the house is sold, we don't get paid right away because the assets from the sale of the estate property are assets of the estate, and that still has to be wrapped up through the proper probate procedures.
So it sounds like the fee, the not the percentage, but the more time the money is out, you guys are compensated for that additional time, basically. So and the less time, the less you guys are compensated as well, too.
Correct.
Amazing. So it like works somewhat like a loan. Like, hey, look, if I make you a loan at 10% and it takes a year to repay back, I'm collecting 10% on that money. If it's 2-3 years, then it's 10% per year, basically, that I'm collecting. Just the fees are a little bit different and unsecured as well, too, which is a lot higher of a risk for you guys if something doesn't work out properly, basically.
They're unsecured, and unlike a loan where there's dates of payment on every first of the month you have to pay X amount of dollars, right? And if not, I'm going to lose some kind of property. It's going to be foreclosed upon. We do not have that. That doesn't have those characterizations of a loan at all. What we do with our fees is we cap them after a year. And so usually we cap them for over a year. If we know there's an adversarial situation or that we're getting ourselves into a multi-year situation based on the nature of the probate and we know that going in, we can prepare for that. But for the most part, we do cap our fees, and the longer, like in these cases I mentioned in New York and some in California, they are if the money's been out for 5 years and your fee is capped, your return is getting compressed each year. But that's part of the business, and that's our one of the many risks that we take on.
And it sounds like part of the way that you guys are able to reduce that risk is by running that judgment of lien, which basically tells you, hey, look, what's the probability of like a Medicare or Medi-Cal coming up towards the end, or a large creditor coming up saying, hey, look, this is owed on this estate, basically.
Certainly, if the decedent had a very long illness, something of that nature, that's a topic to discuss with the estate attorney. Because still at the end of the day, you really don't know. We also, as I said, do a judgment and lien search on our customer. For instance, if there's child support or something of that nature, we are if our customer or would-be customer owes $100,000 in child support arrears and is entitled to receive $80,000 of inheritance, we'll probably pass on that. We're not looking to get ahead of children.
Can any of these funds be used to buy out other heirs?
With the
cash?
Yes. A beneficiary can use our funds to buy out one of the other beneficiaries' rights as well. So sometimes a beneficiary wants to purchase the house, and buying, how do they do that? They need money from us to help purchase the share of another beneficiary or multiple beneficiaries.
What do the typically beneficiaries use the funds for? So I'm imagining one of them is just for living, maybe buying other heirs out. What are the is it to fix up properties, or what do you normally hear?
Sure, it's to fix up properties, and also to move, moving expenses. For a lot of folks, this house has been in the family for a long time. One of the kids has lived with the parents for their whole life, for decades, and now but there are other beneficiaries. So if they're not going to be, if that beneficiary can't buy out their siblings, for instance, then they have to move, and that is just an enormous task for a lot of folks. As you can imagine, I mean that's your business, and to really get a good plan to move out of the house for down payments elsewhere, if it's going to be a purchase, for moving, it costs junk removal of the house. I mean, you're talking about generational move of all the belongings in there. So it's a pretty big task, which requires a lot of money. So that's certainly a primary risk. But also, as I say, yes, for their necessities. If you think you're going to be needing money to pay for your kids' tuition, for a car, for what the stuff that we may take, you're lucky if you get to take it for granted. And if you thought you were going to be counting on the inheritance to continue doing that, that's those personal needs are real. And because they weren't really planned for, not being able to realize those needs, the urgency comes up when the beneficiaries learn there's this probate process.
Let me ask you this. I'm imagining that you guys are not the only company in this space, and that there's other people doing this as well too. Or if I'm considering a loan or a cash advance on my inheritance, what should I look out for maybe somebody who's not doing business the right way, like your guys' company?
Sure. Yeah, there are there are a few other companies that operate in this space. If I'm looking for how can I make sure this is legitimate and I'm dealing with the right people. Number one, I like it that they're talking to the estate attorney. I want to know that there's some level of due diligence being done, that it is a real transaction, that we are doing recorded calls with the heirs, that we are doing our due diligence. I like them to go look onto the websites and say who's running these companies. Is it I'm an attorney? Are the other folks attorneys? What licenses do they have to lose? I look at it being an attorney as a good thing. Others may not, but I think it's it's important to know that they're professionals that you're dealing with on the other side. The other thing I encourage our customers to do is look at the reviews that we have. Go look at Google reviews, and we take that very seriously. We want our customers to understand what they're doing, what the terms of the transaction are, and tailor a transaction that works for them. So there's our folks have a lot of experience dealing with beneficiaries who need money and have the empathy involved. You're working with somebody who needs money, who's just gone through a pretty devastating time of their life with a loss of a loved one, and now this is real life coming. And so you really need to have folks who not only are good at what they do, but also empathize and understand why people need the money up front, not be judgmental. Take the time on the calls with the customers. So yes, people want urgency, but they also want to know that they're being cared by. And when I say cared by, also, if you're not the administrator, you're a beneficiary that has no relationship probably with the estate attorney, and therefore you really don't know what's going on with the probate process. Our company, once somebody has done a transaction with us, you're in our system, and what we're doing is we're following the progress of the probate case. And so beneficiaries who are looking for updates, they can call us now. They don't need to bother the attorneys. So those are important. I look at us also as working as a team with the estate. Oftentimes our advances help the estate. It gives beneficiaries breathing room. They don't have to call the administrator every day. They don't have to call the estate attorney asking for updates all the time. And it just kind of gives everybody a chance to pause, let the lawyers do their job, let the administrators do their job. So, I always make sure that we make the estate attorneys look very good, but it's because of the time it takes. People get frustrated and they want to blame the lawyers because it's taking so long to go through the court process. I know it's not the lawyer's fault. It's the court process. It's the probate process in general. It's how it's designed, and that's why we're in business. It takes a long time for probate to take place, and people can't wait. And people are in the dark, and we provide money and we provide transparency of what's going on with their case.
I love it. Good. Is there anything else that you think would be helpful for consumers to know about Probate Cash?
Probate Cash has been in business for many years now, and we know how the laws work. We also know folks like you, Jose. We can provide referrals for realtors. We can provide for referrals, lawyers to help out, not just lawyers to even open up the estate, because we often get phone calls before the probate is opened up. And so people need lawyers to open up the probate. They're wanting for the first time. They need realtors. They need a junk removal team. They need people to help repair the house. They need a lot, and they're going through a very difficult time. So I mean, as realtors who specialize in probate, y'all are on the front line more than anybody else, and that's you know those people. Now we also, for realtors who are watching, I'm sure there are a bunch of realtors are always tuning into your show, and we get referrals all the time from realtors. It helps realtors even get the listings in the probate cases, because the probate, whomever's going to be the administrator, they're all looking for the money right away, and they may ask you as the realtor, how long is this going to take? And you could say, well, I think I can sell your house in a month or two or a week or two. But that doesn't mean people are getting paid. There's still the probate process. However, information is vital, as you know, and the more resources you have, the better. As a lawyer, you're a counselor. You counsel people, and so the more information you have, the better for your client. And just to know that Probate Cash is a resource out there. When someone's calling you or you're calling them, even soliciting them for the listing, you say, if you need money right now, I know folks who can help you out. I know, let me have the listing because I know everybody, and I can get your beneficiaries, I can get your siblings paid some money right now, and give everybody some time to breathe so nobody makes any hasty rush decisions. And that's needing money, not having money often leads to poor decisions.
Yeah, like selling the property under market value or doing things that don't benefit. So I actually think that this is a great service. I feel that there's a need for it, and I feel that you guys fill that need in the marketplace. Oftentimes administrators can get loans against the property, acting on behalf of the estate with notes and deed of trust, but there's a need for beneficiaries who maybe aren't talking to the attorney all the time or aren't talking to the administrator all the time, that in some cases they run into different things. Maybe they're buying a property and they need to close escrow by a certain time and need some extra funds. So there's a lot of different situations where a beneficiary would benefit from having a solution like Probate Cash. So I appreciate you coming on. I appreciate you taking the time. If somebody wanted to get a hold of your company, how would they do that?
So our website is probatecash.com. It's all one word. My email address is marc, M-A-R-C, at probatecash.com, M-A-R-C at probatecash.com. Although I'm the CEO of the company, I am often very involved in each of the transactions, and I have excellent relationships with the funding executives in our office who you may work with and our underwriters. So I like to know what's going on, and I'll talk to realtors, attorneys. In fact, there's a decent chance I already know the estate attorney from having worked with that person in the past on something similar. So feel free to contact me. And a lot of times this is just also about questions. These are very much no pressure agreements. This this only works if it's right for everybody. And again, it's going to be, the assignment is going to be in court. So there's it's the opposite of no pressure. This is just about making decisions that are right for you.
Fantastic. Okay. Well, Marc, once again, I appreciate your time. To our viewers out there, we had Marc Harris. He's the CEO of Probate Cash. We talked about cash advances on inheritances. So thank you, Marc. I appreciate your time. And to our viewers, until next time.
Thanks, Jose. Thank you.